Welcome everybody to today's event. The name of the event is called Updates on Immigration Law and Practice in Canada, Hong Kong, and the US. It's organized and presented by the Hong Kong Association of New York in collaboration with the Hong Kong Canada Business Association, which we're happy to collaborate with. My name is Donald Moore. I'm the chairman of the Hong Kong Association of New York. I've had that position for 4 or 5 years, I think now. I'm also managing partner of U.S. Legal Advisors, PLLC, and we focus on global security, transportation, and infrastructure projects. Before we start, we'll go through just a couple of ground rules. The program will be recorded, so everybody should be aware of that. That'll be used for promotional purposes. Everybody who's speaking, of course, speaks for themselves, not necessarily for the company that they work for, and those are their personal views and not necessarily their official or employers' views. Everybody's going to be muted, the attendees that is, for the presentation. And if you have questions, please submit them through the Q&A box. Our moderator, who I'll introduce in a moment, will coordinate those and present them to the speakers during the course of the event and near the end of the event. And then if you have any particular questions or trouble, you can send a message to the host who will help you with any sort of Zoom troubles you might have. So next, it's my pleasure to introduce Cindy Ho. She's going to be the moderator and she'll be introducing our speakers and interacting with them. Cindy's the national chair of the Hong Kong Canada Business Association. She's been involved with that association since about 2015. She's a partner in DS Lawyers Canada. And she's a business partner doing mergers and acquisitions in real estate and other matters. And in particular, she helps clients on a range of matters, including domestic and international matters, including in relation to China, Chinese companies needing help in Canada, and Canadian companies needing help in China. So without further ado, I'm going to pass it over to Cindy, who will start the event and introduce the panelists. Cindy?
Thank you, Donald, for your welcoming remarks. Good morning, everyone. I'm truly honored to be moderating this, dare I say, groundbreaking webinar that is organized jointly by HKANY and HKCBA about immigration covering various jurisdictions, including Canada, Hong Kong, and United States. Such regions with such rich cultures, diversity, and affluence of job opportunities remain inevitably a destination that's ideal for immigration, whether it's for work, family, and immigration law is a specialty that's always evolving. Clearly not one of my specialties, so I'm thrilled to have seasoned experts who practice in this field in all 3 jurisdictions today, who are specialized and will be talking to us about both inbound and outbound immigration law practices, the latest programs available, and especially the latest updates with COVID protocols and much more. So I would first like to introduce you to Maître Marc-André Séguin. He is the co-founder and partner at XAO Attorneys. Marc-André is a member of both Quebec and New York State Bar. He has been practicing immigration law since 2010. He has published a widely read handbook about Quebec Immigration Investors Program and has developed business relations with industry professionals in over 20 countries. In addition to mastering both civil and common law, where he graduated from McGill University, Marc-André also holds a master's in Asian legal studies from the National University of Singapore. He can speak English, French, Spanish, and is currently learning Chinese. Marc-André will speak to us today about updates from Canada, and namely business immigration paths to immigrate permanently and temporarily to Canada, including work permits for intercompany transfers, entrepreneurs, skilled immigration, permanent residency programs for entrepreneurs and innovators, and provide, obviously, as I mentioned before, a brief overview of the COVID protocols for travelers coming into Canada. Bonjour, Marc-André.
Hello, pleasure to be here. So thank you everyone for the opportunity to talk about this exciting subject today. Canadian immigration law has been through a lot of changes since March of 2020. And what we're going to do today is try to give you an overview of some of the core programs that we see in Canada as things stand today. Obviously, It's, we can't, let me see if I can share my screen here. Obviously, the purpose of today's meeting is not to give you information about every single immigration program that exists in Canada. That would take us hours, if not days. The purpose is to give you just a core idea of what are the current, the most typical programs that we will see in use in Canada today. I'll spare you the disclaimer, but obviously whatever we discuss today does not constitute legal advice. Every situation is specific, and do make sure that you talk to a licensed advisor before undertaking any immigration plans to Canada, whether it is permanent or temporary. A bit of information about our firm. I'll let, obviously this particular presentation will be made available to everyone. If you want to learn more about who we are and what we've done, feel free to reach out to us after today's presentation. Now let's get into it. Generally speaking, under immigration law in Canada, there are three main reasons for someone to enter or to cross the border. There's either, you'll find visitors, so people who come to Canada to either visit Canada as tourists or as business visitors. You have temporary statuses as well, primarily for workers and students. We're not going to touch on study permits today. However, do know that they fit in the temporary immigration category, otherwise known as mobility. And then you have permanent immigration. So people who have a permanent intent towards Canada, who want to acquire permanent resident status and possibly eventually Canadian citizenship, which is the second step for some after becoming permanent residents or PR holders. We will start with permanent immigration. I'm going to briefly talk about two specific programs that lead to Canadian permanent residency. That being said, there are literally dozens across Canada. There are provincial programs, there are federal programs, there are categories for self-employed workers, primarily artists and athletes, as well as for entrepreneurs across the country. So it's important to know that there is a vast world of permanent residency programs beyond the two that I will present today. The first one is a federal program, otherwise known as a Canada Startup Visa or SUV. It is a program that leads to the Canadian Green Card and is designed for entrepreneurs who are involved in an innovative business that is likely to benefit Canada's economy. The idea here being that the federal government wants to attract essentially those Silicon Valley types entrepreneurs from around the world so that they can come and develop their technology, their innovative ideas in Canada. In order to qualify for this particular program, it's important to know that no minimum investment is required. The primary element that the federal government is looking for here is a validated idea, validated by either angel investors, venture capital funds, or incubators. Provided that the entrepreneur secures the support of one of those three federally licensed organizations, whether they're angel investors, venture capital funds, or incubators, the list of which is found on a federal website. That entrepreneur will be allowed to come to Canada and launch their business. Success is not a requirement, although a good faith effort is. The applicant is required to actively manage his or her business in Canada. They may even team up with Canadians, but the important thing is that they first have the support of a federally licensed organization. In some cases, in the case of angel investors or venture capital funds, they must even secure funding from those organizations in order to qualify. The idea, again, being that these particular businesses can come and develop these new technologies and benefit Canadians as a whole. Obviously, most other immigration programs that we'll find across Canada also require very active involvement in businesses today. We will find such programs in Ontario and in certain other provinces as well. These programs are also known as provincial nominee programs. We will not discuss those today just for lack of time, but by way of comparison, I also wanted to introduce the well-known Quebec Immigrant Investor Program, very well-known in Asia, particularly in China and in Hong Kong. The reason why I am mentioning this program, even though it is currently and temporarily closed is because this is the only passive investment program that currently exists in Canada, leading to permanent residency. Obviously, this particular program, contrary to certain other active investment programs, requires the applicant to display a very large amount of minimum net assets, management experience, as well as, and also introduces a very high investment threshold. So in order to qualify in this particular case, an applicant would have to demonstrate at least $2 million in net assets, 2 years of management experience in the last 5 years, and then make an investment, a qualified investment through the, essentially amounting to the purchase of a government issued bond for 5 years at 0% interest, the purchase of which is priced at 1.2 million Canadian dollars. However, because this is a bond-based investment, all financial institutions that are currently involved in the program, which must be licensed by the Quebec Ministry of Immigration, also offer a financing option priced at around $380,000 currently. The investment in this case is secured by a government issued bond. That's why there is a financing option available. The investment in this particular case is only required upon acceptance by the authorities, which is different from the other programs where the investment is one of the first steps of the process. It's extremely passive as well, and unfortunately is currently closed, but we are expecting further news on this program probably in the coming weeks. It's also, just like the other programs, it's a direct path to permanent residence, with the only exception that because this is a provincial program, the first step is to be approved by the province, to be selected by the province of Quebec, or otherwise nominated by the province, and then the applicant will be able to move on to permanent residency. Now, so very quick overview of the permanent residency landscape. Now we're going to be moving on to two visa categories for workers. So mobility, otherwise known as temporary immigration. The first one that we'll discuss is intercompany transferees. This is a very popular work permit. Also very popular in Hong Kong because it is not subject to consular processing. A Hong Kong applicant holding a BNO or Hong Kong passport can go strictly to the port of entry when applying for this particular work permit and bring their application at the port of entry at the airport. And provided that the application checks all the boxes, the applicant is able to leave the airport with their work permit in hand within a couple of hours. This particular for intercompany transferees, managers, employees with specialized skills who have been working out of a multinational group outside of Canada for at least 12 months. And are now moving to Canada in that same capacity, working for the Canadian affiliate company. The affiliate company can be a startup or an existing company. And that particular difference, whether it's a startup or an affiliate company, will also determine how long the initial visa is granted for. The company obviously must have a qualifying relationship. So we're talking about affiliate companies. The renewal of these work permits is valid for up to 7 years for managers and up to 5 years for employees with specialized skills. Another work permit category that is particularly interesting is the C11 Work Permit, otherwise known for a work permit that is specifically designed for entrepreneurs or self-employed candidates. In this particular case, a foreign affiliate is not required. It does not require a multinational structure. However, it does require a substantial investment on the part of the investor or entrepreneur coming into Canada, and that particular person must have a majority stake in that business. They're allowed to team up, but they must have over 50% of that particular company's shares in order to qualify for this work permit category. This particular company has to offer a significant benefit for Canadians and for the Canadian economy. That's why a substantial investment is required. That investment is not, we don't give out a specific amount, but is generally understood to be a non-marginal investment. So you can think at least $100,000 into a business in order to qualify, but that particular threshold will change depending on the particular industry that the investor is interested in. We need to show a clear business plan as well as concrete measures that were taken in the furtherance of that plan before applying for that particular work permit. It's important to know also that for several months now, the Canadian federal authorities have engaged in special measures for Hong Kong SAR and BNO passport holders. I won't go into all of those policies today. But one of the things to bear in mind is that, of course, Hong Kong SAR passport holders are visa exempt. That processing is prioritized at the moment for family reunion and study permits applications, and that some applicants holding the Hong Kong SAR or BNO passports can apply for work permits for 2 years without any regard to the physical location of the applicant. I say some because that particular open work permit option is available generally to people who currently have a work permit in Canada or who have been studying in Canada or who are relatives of Canadians, Canadian permanent residents or citizens. That particular application can be submitted online. And finally, COVID and the Canadian border. There have been a lot of policies that have changed over time. The core takeaway here is that Canada, since September 7, has opened its borders to all visitors as long as they are fully vaccinated, utilizing a vaccine that is recognized by Canadian authorities. So that refers to Pfizer, Moderna, AstraZeneca, as well as Johnson & Johnson. The traveler must have been fully vaccinated for at least 2 weeks before entering Canada. Fully vaccinated travelers are exempt from quarantine. However, they must bring a PCR test with them that was taken at least 72 hours prior to arriving in Canada. And there can be some random PCR tests upon landing in Canada for those vaccinated travelers. The only unvaccinated travelers that are currently allowed in Canada are those that are non-discretionary, that are traveling for non-discretionary reasons, mainly study permit holders, workers, permanent residents, and citizens. But their situation is about to be significantly more complicated by the fact that the federal government has announced very recently a new policy. And therefore, starting October 30, 2021, in just 2 weeks from now, any passenger on any flight or interprovincial train trip will have to be fully vaccinated before being allowed to board. That policy is likely going to be challenged in court, so we have to wait to see what happens, because one of its impacts is that it might forcibly keep unvaccinated foreign visitors in Canada against their will, because they simply will not be able to board any flight or trains. And the US border, the only land border that Canada has, will reopen in the next few weeks, starting in November, but only to vaccinated travelers. So again, we might find ourselves in Canada with several visitors who are stranded here without the ability to leave, simply because they will not be allowed to board or exit through any means of transportation. So that's likely going to be challenged. There is some that we will need to keep following up on that in the coming weeks and months. That's it from me. I look forward to answering questions, and thank you everyone for attending here today.
Thank you, Marc-André, for your presentation. It is super interesting. Maybe I'll just add one question right away. In your presentation, and I know it's a question I get asked a lot from my clients, and you mentioned that the Quebec Immigrant Investor Program is temporarily closed, but news will come. Do you know if it will be reopened by the end of this year or maybe even in 2022?
So the latest that we've heard is that the Quebec Ministry of Immigration has in fact reached out to the 18 or so financial intermediaries that are involved in the program to set a special meeting next Wednesday on October 20. Wednesday is generally when regulations and ministerial decrees are published in the official gazette. And therefore, that is no coincidence. What we expect is that there will be a formal announcement published next Wednesday prior to that specific meeting. What the announcement will be, we don't know yet. It could be that the government is just kicking the can a bit further down the road, or that the program will be reopening on a very limited basis. So we need to basically wait and see. However, we can expect at least some more news in about 7 days.
Wow, that's super exciting. Maybe just another quick follow-up question. You also mentioned that there's some special measures for Hong Kong, mainly for work permits. Is there any possibilities for residency afterwards?
Yes, so anyone who has at least 12 months of valid work experience in Canada full-time can apply for the Canadian Experience Class category under which is a federal program under which an applicant can apply through the platform Express Entry. So there is a pathway to permanent residency for workers who have accumulated sufficient full-time employment in Canada.
Perfect. Thank you so much again, Marc-André. Marc-André will be back with us later at the end of today's webinar to answer more of your questions during the Q&A section. Please feel free to ask any questions using the Q&A function at the bottom of your screen or top of your screen, depending on how your Zoom is configured. I am now honored to introduce to you Mr. Stephen Barnes. He is the co-founder of the Hong Kong Visa Center. Stephen graduated with honors degree in law from the London School of Economics in 1992 and successfully completed the solicitor's final examination at the Law Society of England and Wales in 1993. Having lived in Hong Kong since 1987, he has exclusively practiced immigration in Hong Kong since graduating law school. And in 1996, he wrote and hosted on the internet for free, the definitive practical guide for business immigration in the HKSAR, and now published on one of his 4 Hong Kong visa and immigration websites, HongKongVisaHandbook.com. A regular guest on RTHK, the public broadcaster in Hong Kong, Stephen frequently offers commentary on business immigration live on air and is this time the best of his knowledge and the only person presently credited for the Law Society of Hong Kong to deliver CPD programs on the topic of business immigration and HKSAR. Stephen will provide us with an overview of immigration law in Hong Kong with the constantly shifting COVID quarantine and eligible travelers, welcoming foreign talent and businesses, enhancements of the national security law, background check. Welcome, Stephen.
Thank you, Cindy, and good morning, everybody. It's a pleasure to be here with you, sharing with you for 15 or 20 minutes my favorite subject, Hong Kong immigration. So we will sort of start off with the ramifications of visitors and residents coming to Hong Kong predicated on the fact that we've got a zero COVID policy here, which impacts somewhat significantly on your ability to move freely across our boundaries and to get into Hong Kong via the airport. I'll touch then briefly on what are the 4 main sort of immigration stati that are used by foreign nationals to be able to pursue their sort of residence objectives in Hong Kong. I'll speak to the fact that we do have an open door policy. Nothing's changed as a result of recent adjustments to national security law arrangements here. And I'll also then just have a minute or two on sort of what's perceived to be a bit of an exodus from Hong Kong as a result of the national security law and the availability of the British national overseas. New visa arrangements in the UK for BNO passport holders. If you are thinking about coming to Hong Kong, you would no doubt have looked really carefully on the government website to see what the arrangements are as regards being able to physically enter. Well, it's quite a complex sort of matrix of different arrangements, depending on where you're traveling from, what your vaccination status is, and other things. But for all practical purposes, it breaks down into whether you have to do 7 days quarantine, 14 days quarantine, 21 days quarantine, whether you can do that quarantine at home, or whether you can, or you have to do that quarantine at a designated quarantine hotel. So presently we're broken down into 3 categories. We've got high risk category, which requires a 21-day quarantine arrangement in a designated quarantine hotel. We have, and the USA is a high risk category A, group A country presently. We have medium risk, category B, and Canada is a category B country presently. That's a 14-day designated quarantine hotel arrangements. And then you have low risk, which at this point in time is only one jurisdiction, New Zealand, non-Chinese jurisdiction, which is New Zealand, which requires 7 days in the designated quarantine hotel. Home quarantining arrangement is only available to those travellers coming from Macau and China and who are vaccinated. And there are different arrangements in place as to whether you're a Hong Kong resident or a non-Hong Kong resident. Similarly, if you're coming from Taiwan, it's a 14 or a 21-day designated quarantine hotel arrangement, again, depending on your vaccination status and otherwise. There are some schemes afoot that are making it easier to cross the border between the boundary between China and Hong Kong. The return to Hong Kong, that's for Hong Kong residents, and the come to Hong Kong scheme for residents of China that want to come and avail of themselves in Hong Kong without needing to undergo formal quarantine upon arrival. There are challenges getting back into China as a result of having come to Hong Kong under the return to Hong Kong or come to Hong Kong arrangements. But in very broad terms, the zero COVID policy is making life very difficult for people to get here easily at will, and entails some considerable delays to your planning because of the limited number of designated quarantine hotel slots available. So good planning is required if you're planning to come to Hong Kong, but you can come. The borders are not completely closed, but if you are coming from the USA as a category A country, you, as a visitor, you're not permitted presently, irrespective of your vaccination status. So, as I say, some planning is required. So the door is open. The Immigration Department is still accepting applications and processing applications in exactly the way that they've always done pre-COVID. The main 4 visa types that I'm going to focus on are heads of immigration activity that lead to the grant of particular visas predicated on your rationale for wanting to come here. I'll just go through those briefly and then just say a word or two about permanent residency, which requires a full 7 years of continuous ordinary residence in Hong Kong after having held a temporary, so to speak, visa for 7 years, availing you of the opportunity to adjust your status and become a permanent resident subsequently. So the 4 main visa types are the employment visa issued under the General Employment Policy for professionals. And this entails also those individuals who are perhaps moving to Hong Kong on the basis of being intercompany transferees, working for a foreign organization that's got a business operation that's well established in Hong Kong, who's in a position to support and sponsor the incoming intercompany transferee for an employment visa. The test for approval for an employment visa under the General Employment Policy is that the applicant must possess special skills, knowledge, or experience of value to and not readily available in Hong Kong. But more broadly, the compensation must be broadly commensurate with market rates paid to similar professionals in Hong Kong, which I guess is similar to all other jurisdictions. And that for the most part, the Immigration Department needs to be satisfied that no local person can reasonably be expected to uptake the work that's proposed for the foreign national employment visa applicant. So on the basis that they are a professional and otherwise all matters are properly addressed, generally speaking, these visas are being issued without any challenges, without any problems. There are a little bit longer processing times as a result of national security law, more detailed background security checks that are ongoing now. But otherwise, it's business as usual for any professional that wants to be in Hong Kong to take up employment. So that's the first visa type that represents probably, in normal times, about 17,000 approvals each year that facilitate the inbound traffic of foreign national professionals to take up residence here. So the second visa type that is used by foreign nationals to engage in business here is the business investment visa as an entrepreneur. And this requires that the applicant be able to demonstrate to the Immigration Department satisfaction that they can contribute substantially to the economy of Hong Kong. That's the test for approval. In broad terms, what does this mean? Well, it means that the Immigration Department are looking for what I've couched as the three legs of the approvability stool. As long as these three components are in place and addressed and are persuasive in the context of the plan for the business that is driving the application for the visa in the first place, the Immigration Department are amenable to granting approvals for this particular visa type. So this is the first leg of the approvability stool, is that through the plan for the business, there must be a clear pathway to the creation of local employment opportunities. Typically, substantial contribution to the economy of Hong Kong precludes those foreign nationals who want to come and establish sort of, one-man consulting enterprises. For the most part, there has to be a plan for jobs in the offing in order to get this visa. The second leg of the approvability stool is the Immigration Department expect to see that there is a properly set up office in Hong Kong. This is the language from the policy. And the properly set up office used to be a big bugbear, arguably the most expensive component of getting the visa approved. However, thankfully, we've got, over the last 7 or 8 years, we've developed a significant ecosystem of co-workspaces here. So co-workspace arrangements, which are relatively cheap and cheerful to set up, mean that a properly set up office can be suitably addressed with a minimum of fuss to pursue the visa application. So that's the second leg of the approvability stool, as it were. And then the third leg is really what I've couched as resources, two types of resources. There's funding resources, and there's resources which speak to sustainability of the business. So funding resources, this is really all about demonstrating to the department that you've got sufficient financial means to, on the one hand, commercialize your business plan, and on the other hand, ensure that you've got sufficient financial means to be able to meet your financial commitments as they fall due. The quantum isn't fixed by policy, but $1 million Hong Kong dollars, generally speaking, which is about 120, 130,000 US dollars, that generally ticks the box. So it's not a particularly expensive program to need to fund to get this visa for. But necessarily the actual quantum that the Immigration Department wants to see is a function of the business plan. So if your business plan clearly calls for more capital than that, then you obviously need to have $1 million Hong Kong as a minimum, and then a clear sort of path to being able to procure the rest to ensure that your business plan is properly actionable. And then the other side of the coin in terms of resources is the resources which speak to the sustainability of the business. The Immigration Department are not going to approve this particular visa type if they're not satisfied that the numbers that are promulgated in the business plan are not capable of being achieved in fact. They don't want to see the business fail for want of commercial prosecution. So there has to be something sensible put before them that speaks to your ability to actually deliver on the numbers that go to make up your plan. So in broad terms, that's what the Immigration Department are looking for when it comes to this particular visa type. It's an arduous process. It's 4 to 6 months, normal processing times. It's the immigration department can be a little bit picky and choosy depending on how the economy is. They're being a little bit picky at the moment, so they're not making it easy. Generally, when the economy is flying, they're a little bit, let's say, more they're more liberal in the grant of the visas, but at the moment they're being a little bit more conservative. I'm not sure why that is, but we're still getting these visas approved. There's not as many of them around these days as there were prior to, you know, the troubles starting in 2019 for obvious reasons. But I think once we get our borders open again, we'll see a significant uptick in those visa types coming across our practice. The third visa type is really supportive of the first two in as much as they are available for family reunion. And there are two particular visa types that avail family reunion in Hong Kong. One is the dependent visa, and the other is an out-of-policy program that the Immigration Department have put together based on prolonged visitor consent for de facto spouses who haven't recognized their relationship in any legal fashion. And these non-traditional relationships are afforded some measure of recognition by the Immigration Department because they don't want to separate families. But it does have the operating difference on the visa type as to who can work and who can't work, depending on which visa type that you hold. So the visa type for married couples, heterosexual or same-sex, or whether their relationship is recognized via a legal marriage or whether it's recognized via some other civil partnership or other instrument that legally recognizes their relationship in the jurisdiction where it was celebrated. These people can qualify for dependent visas on the strength that the Hong Kong resident visa holder that's seeking to sponsor the family member can demonstrate to the Immigration Department's satisfaction in broad terms that they can put a roof over their head and food on the table of their family member that's accompanying them for residence in Hong Kong. The situation for unmarried partners is the prolonged visitor visa. The prolonged visitor visa is granted in 6 monthly increments. They are readily extended every 6 months whilst they're in Hong Kong. However, the difference between the two is that under the dependent visa, which requires legal recognition of the relationship, privilege to work is availed. Under the prolonged visitor visa for de facto spouses, the holder doesn't get the privilege to work. So there is quite a powerful difference between the two types of visas, depending on, you know, the status of the relationship with the sponsoring Hong Kong resident visa holder or the applicant for the Hong Kong resident visa. So that's the family reunion dimension addressed. And then there are a number of permutations on the employment visa typically stated that are also available in Hong Kong, depending on whether, for example, you studied in Hong Kong and graduated from a registered tertiary education institute here with a degree, either a bachelor degree or a master's or a postgraduate degree. That avails you direct access to a no questions asked, no employer required automatic employment visa at the end of your period of study upon proof of your graduation from the university here in Hong Kong under the immigration arrangements for non-local graduates. That's a very flexible visa type, and it does provide a kind of a pathway to employment status for some individuals who might otherwise not be able to qualify to secure an employment visa as a professional. So that's one kind of permutation on the employment visa. There's another permutation that's designed specifically for mainlanders, residents of the mainland, under a program called the Admission Scheme for Mainland Talents and Professionals. This is very much like the employment visa that's issued to other foreign nationals under the general employment policy, but it has a higher bar to entry because there's plenty of people in China that would like to come and live and work in Hong Kong, so the Immigration Department don't make it particularly easy for them to secure this status. They have to typically have a master's degree or at least a bachelor's degree with a minimum of 5 years post-graduation working experience in the case of possessing merely a bachelor's degree. And the sponsoring employer in Hong Kong must be a very well-established company. And then there's the training visa, which allows you to secure status in Hong Kong for between 6 and 12 months to undergo training in Hong Kong for particular skills that are otherwise not available outside of Hong Kong. And again, you need to have a well-established employer sponsor to sponsor those training visas, but you can get permissions to come to Hong Kong specifically for training under a permutation of the employment visa. And then one other status that's available for existing employment visa holders that have been able to secure a 2-year limit of stay on a prior application and have that status available to them at the time that they apply for what's known as top tier status. And basically what that means is if your taxable salary income in the most recent tax period was 2 million Hong Kong dollars or more, then you can apply to extend your current employment visa and remove any sponsorship requirement from your current limited stay and secure a 6-year one-time extension under the top tier scheme. So that's a program that is particularly useful for those individuals that have the means to earn those kind of incomes and then get an immigration advantage thereafter, which gives them a kind of a clear sort of, immigration pathway through to the 7-year requirement of continuous ordinary residence in Hong Kong to be able to subsequently qualify for permanent residency after 7 years. So that's... Yeah.
Sorry to interrupt you. Actually, this is a super interesting opportunity that you're mentioning. Are there any opportunities to secure this passive investment for residency visas in Hong Kong? Is that the one you just mentioned before, or is there another one that is available to potential immigrants?
Well, we used to have a passive investment for residence program, which was initiated in 2003, but was postponed indefinitely, and I'm not sure that we'll ever see the light of day again, called the Capital Investment Entrance Scheme, which is where you effectively put 10 million Hong Kong dollars into qualifying investment asset classes, waited 2 to 2.5 years to get to the back of the queue. And then all things being equal, if the immigration department were happy with you, they would avail you of this capital investment entrance scheme visa, which was basically yours for 7 years on the basis that you maintained your ring fence qualifying investment in these particular assets in Hong Kong that qualified for the visa. That's gone now. So there is no formal passive investment for residence visa at this moment in time, but there are some creative ways to skirt around that quite properly. And I have 1 or 2 of these that occasionally come across my desk. So if anybody's ever interested in that, then I can have an offline conversation with them about it. But no, fundamentally there isn't, but like all good lawyers, there's always a way to get things done, right?
Thank you so much again, Stephen. And I know you'll stay with us at the end of the webinar. Again, I already see some questions coming in. Please feel free to ask any questions to any of our panelists using the Q&A function at the bottom of the top of your screen. I will now introduce you to our last panelist, but definitely not the least, Mr. Raymond Wong, who is the founder and president of Wong & Wong Associates. Over the years, Mr. Wong has carved out a reputation as an expert problem solver and fierce litigator handling civil litigation, criminal defense, and transactional matters. Mr. Wong's educational background in the fields of electrical and chemical engineering is reflected in his precise, logical approach to legal problems, which his experiences as a former soldier in the U.S. Army National Guard accounts for his prominent ability to strategize and fight in our adversarial legal system. Since founding the firm in 1988, Mr. Wong has helped countless clients in their legal needs. He is born in mainland China, but raised in Hong Kong and moved to the US in his teens. Mr. Wong understands the unique needs and concerns facing Chinese Americans, and Hong Kongers attempting to navigate the US legal system. Mr. Wong is licensed to practice law in New York and New Jersey, and he is the vice chair and board member of the Hong Kong Association of New York, and he is also the founder and chairman of the board of the Chinese American Bar Association. And today, Raymond will present to us the most common paths to come to the US, such as family-based immigration, work visas, student visas, visa lottery, and special treatments for Hong Kongers and recent policy changes under the Biden administration. Welcome, Raymond.
Thank you, everyone. Apologize the noise outside, there's a little construction outside, so there may be a little noise affecting the talk today. The US immigration is a big topic, so I wouldn't be able to finish that in a few minutes. But I will refer you to, if you have time, to go to the website of the USCIS, the US Citizen and Naturalization Services. And they have very good forms that where you can look up and see how everything is done. And also, I would ask you to hire a reputable law firm to help you with whatever needs that you may have. Immigration law in the United States evolved very slowly. People, if remember studying from law school, there were Chinese Exclusion Act in the 1800s. So like it didn't really treat the Chinese that well back then. But things have evolved. And recently, the big change is the US-China relations, the fact of the change on the immigration for the Hong Kong people. Since I'm an immigrant from Hong Kong, so this is a topic affected a lot of the people that I know. The Trump administration decided to have an executive order after the security law in Hong Kong. So they suspended the treatment of Hong Kong people, treated like a separate territory. So the visa, the treatment will be the same for Hong Kong people as the Chinese people now. So coming to the United States would be a little bit more difficult for the Hong Kong people. And also in terms of immigration, the biggest part of it is family-based. I immigrated to the United States by family-based. And there's also, since this is a Hong Kong Association in New York, I would think it's basically a business community. So there will be a lot of business immigration, like L1 visa, H1, people with abilities. And I think like all jurisdictions, people would want to get able people to come and work in the United States. So depending on your skill sets, I mean, there are skilled employment and unskilled worker. So depending on what is your status, so you can talk to the immigration expert and to see where you fit so you can come. With the laws in 1990, we don't have any new immigration law per se. Since 1990, there was a limit of 140,000 business people, skilled people that can come in the United States, and only 7% of that per country. So the law is stacked against big countries like China and India. So there's a long waiting list. And Congress knew that. And I, as a matter of fact, when I was a young lawyer, I actually wrote a letter to Senator Schumer, who was in charge of the immigration policies. And now he's the majority leader in the Senate, to reflect that why is that the case? I mean, why there's so little quota. We do have a quota for these big countries. And fortunately, last year, there is a called the Eagles Act, where both the House and the Senate passed the bill, but it hasn't been reconciled to allow that 7% to be 15%. So there will be more people coming to the United States from those two countries. So that is the latest development. Another development is the Biden administration in August passed an executive order. Now, since there's no new laws that are coming out, and presidents have been using executive orders exclusively to make change in America. If people remember that during the Trump administration, let's go back to Obama administration, that he actually sent Gary Locke to be the ambassador to China. And that made profound change in the visa policy, that from Chinese national used to have to wait for like 70 days to get a visa approval to 5 to 7 days. So that is a big change in terms of visa improvement during the Obama administration. During the Trump administration, because the relationship between US-China was chilled and the immigration process was going very slowly. So you see things are getting approved very late and maybe not even being cared for because of most new immigrants are Democrats. So it becomes very political. And with the Biden administration, he actually followed the same policy with Trump in terms of treatment of Hong Kong. And he came up with, in August, he came up with new executive order to allow people from Hong Kong to stay in the United States for 18 months, so-called safe haven policy. Now, that is a very important policy because if you come to the United States, there are many ways to stay. The easiest way people stay is to marry a citizen because there's no quota. If you marry, that's presumably you're single, and people would go extreme to divorce their spouse and marry an American citizen. And from my practice, I'm surprised by many of people are dating on the internet. So you have Americans actually dating people in China. And I remember in my New Jersey office one day, a couple came in, they don't talk to each other. The husband speaks English, he's American. The wife spoke Mandarin and with me. And I say, how do you communicate to each other? They use Google translation. I say, wait, would that work with the immigration to think that that may be a bogus marriage? But that's how the new world works with family-based kind of cases. So since the limitation of time, I would just go that from the past, the treatment of Hong Kong, now part of China, has not been so favorable, but it's getting better. And from a non-civil society to a civil society, it takes time. And we can see the riots that we had in our capital. So with the immigration, it's the same thing. And I think that is a long process. It's going to the right way. But for people that are enjoying coming to the United States, is very much like all other nations. People are looking for better opportunities. And I think from the point of our country, the United States, we want able people to come, like the intellectual, like Yao Ming. He had no trouble because that would be our national interest to get someone have extraordinary abilities to come to the United States. But we also have foreign workers coming to do their fair share of the work. So the immigration practice is very, very broad. As the introduction earlier said that I'm a litigator, but I'm being forced to do immigration by default because first of all, I was an immigrant from Hong Kong, and all my clients are basically from Hong Kong, China, and elsewhere, a majority of Chinese national. And for the last 30-some-odd years, I can escape immigration law. And also the Chinese in mainland are doing better and better. So there are more subsidiaries that actually come to the United States and expand their business. A word of caution is that try to hire reputable people, because I have very well-to-do people hire immigration services, get them papers submitted, but they were not accurate papers. And with any immigration officers, the custom, if you make a mistake with your application and then during the interview, it doesn't pan out, you're in trouble. Because our country are very strict on laws. If you make one mistake, they will deny your visa. And it happens to so many people. In the past, they didn't think much of it. They just do whatever they want to put in the petition without being careful. And they submitted different record of their college education, like in different times. So even you're a millionaire, you hire the biggest law firm, you wouldn't be able to prevail if you don't do things accurately. So that's all for now. And it's a big topic, and I hope my talk is helpful. Thank you.
Thank you so much, Raymond. Definitely something that I keep a close eye and ear out for. It's always changing, as we mentioned earlier. I was just wondering, you mentioned a little bit to make sure that you hire, professionals to be able to assist you in preparing your immigration packages as, properly as possible. What's the most common problem that you see? Maybe an example of one when, immigrants are trying to apply for the visa so that they could maybe avoid it beforehand or prepare their files better?
I think the biggest problem is not accurate. No matter what you do, when you make a statement. I mean, these forms are standard forms. And when you fill it in, it has to match during the interview. And if you submit once, it should be the same when you submit the second time. I had a client who wanted to open a business, like a trading company in the United States, hire an immigration services. And he actually had a college degree from a university from China, but he put down military. So that was a red flag. And also he submitted a second graduate certificate were very different from the first one. So he spent years trying to come. He spent about $8 million already investing in his business locally, trying to set up a company to do trading between the United States and China. And he wasn't able to come because of those mistakes he made by hiring non-professionals. And I can understand people would try to do anything to get the original entry he got here before, but when you do the green card process, it didn't match to the first time when you do your visa. That's a big problem. And many people from a different country, they like to say whatever they want and not be consistent. And what they say do not match with the paperwork. That is repeated time and time again. And it causes people to be denied entry, even they have legitimate visa before, and they are forever barred to come to the United States because they lied. So that is a terrible result to many families, because some of them were married couple, and the husband is in the United States, wife had an H1, went to China, visit someone, came back during the interview, did not give a true statement, and she was denied entry. That broke the whole family.
Wow, that's very, very sad story.
Very serious, very serious. And recently, we're seeing more litigation now because of visa fraud, quote unquote, being politicized. And we're handing, people from mainland China going to exchange program, J visa, and they're being prosecuted for being spies, maybe, or doing bad things for their country. Yeah. So it becomes politicized now, and you would never see anything like that remotely to being prosecuted in the federal courts. It's crazy.
So one of the questions that I had is obviously, I think that maybe it'll be a good segue. I'll ask a few more questions to Raymond, but then we could segue through our Q&A session. So again, a reminder to everyone, I know there's some questions coming in already. Please feel free to use the Q&A function at the bottom or top of your screen to ask any questions. Maybe another question for Raymond. Let's say if we set up a subsidiary, that, like you said, maybe the entry into the US, the first part was not, I'm not going to say easy, but achieved successfully. And then because when we're applying for the long-term, more permanent stay, there are issues or let's say a subsidiary is closed off. Is there any alternatives to, finding alternative solutions for being able to stay in the country, or, different statuses that could be applied to, or once there's an error or a problem with your immigration process, you have to start all over and have more difficulties afterwards?
I think ultimately our services are very reasonable. I mean, I think that if you can explain why you make that mistake, and I think that is curable. I had clients where they commit crime in the United States when they were college students and they were denied entry with visa. But we actually got their criminal record and explained the circumstances, because some situations where people plead guilty just to get out of trouble, to save money, and they may not have done it. So what you do is that you vacate those criminal charges. I mean, try to vacate it, because incompetent counsel. So many of these forms that were submitted or documentation were submitted may not be by the petitioner themselves. And some services, they actually put their own stuff in there. I remember there was a political asylum case. A 25-year-old came to my office. He's a young man, and he said, "Can you do an appeal for me?" And I say, "Do you know why were you denied?" He said he doesn't know. I say, "Are you married?" He said, "No." I say, "You have children?" He said, "No." I say, but your petition put down for one-child policy. You are not married, you have no kids. I mean, you're going to get denied. And he had no clue what was submitted on his behalf. So that was a crazy situation. So many of these things that were submitted can be curable if you explain it to them. And I think our immigration have a process for that incompetence of counsel, and you can open the case and then you can resubmit those papers again.
We have another question for you, Raymond. You mentioned that immigration now treats Hong Kongers same as mainlanders. How does that affect the quota for EB2 visas, employment-based green card?
It would be treated the same now, like the Chinese national. The favorable, in the past, there are different quotas. I mean, for one country, two system. So if you treat Hong Kong people separately, and then you wouldn't be on the queue of the China queue. So the China queue is much longer, right? Because the 7% per country since 1990. So now the Hong Kong people are getting in line with those people in China. So everything will be delayed if that's the case.
Okay, perfect. I think that this is a great segue. I have another question for the general, all the panelists. And namely for Raymond and Marc-André, one of the questions which I think is very difficult to answer is between Canada and US, which country is better for immigration? The million-dollar question, I suppose. Maybe it'll be easier if we talk about the two immigration and pros and cons.
I think that depending on the person's need. I mean, there are people like Canada, there are people like the United States. Coming to the United States is much harder because of the current environment, anti-foreigner. So I think Canada has an upper hand in that. I still remember back in 1997 when Hong Kong was reverted back to mainland China, a lot of people went to Canada. Canada are smarter people. I mean, they make good policy. And I think Americans are not smart. They make poor policy. We train these professionals and we kick them out. We don't keep them. It's crazy. But that's what a messy Democratic Party that democracy we have. We have to look out for the union who are fighting like people don't want to fight for their job. At the same time, we need these people in our country. We're just making bad policy. And now we're done with the investment policy since 1990, and there's no new laws allowing people to come in like 500,000, 1 million. But Canada is smart. I mean, they have a lot of these incentives to and it's a big country and a lot of room for growth. So I think we're losing out in that competition. But ultimately, it boils down to what the client wants. I mean, if they want it bad enough, they will find ways to come.
Thank you, Raymond. Marc-André?
Sure. To complete what Raymond just said, so I practice immigration law in both Canada and in the US. So we face that situation on a very regular basis. I would say that the US immigration platforms are interesting for family reunification, are definitely more efficient than Canada's, and are faster, generally speaking, especially for spousal sponsorships. For other types of family sponsorships, it can be significantly slower. I think for Mexican citizens, for example, they're currently processing family sponsorships that were filed in 1996. So, but for spousal sponsorship, it's much faster than in Canada at this time. The US EB-5 program that Raymond alluded to currently is open at $500,000 US, which makes it probably one of the cheapest business investor immigration programs in the world at the moment for any OECD country, at least, provided that you apply under EB-5 direct, which is, we don't have time to get into that, but in any event, it is something that is worth exploring. And in Canada, on the reverse, I think Canada has displayed quite a lot of potential for to essentially help applicants bridge from a temporary status to a permanent one, which is significantly harder to do in the US. So, for instance, students or temporary workers who come to Canada and acquire skills or experience have that possibility to then bridge over to permanent residency and ultimately citizenship. However, I would say that our business immigration programs right now, unless you want to be actively involved in a business or that you have a great startup idea, are probably inferior to what you'll find under the EB-5 or the EB-1C visa categories. So there is, it's a give and take. It depends. Again, there are as many answers as there are people who might be interested in one country instead of another. They're very different countries with very different immigration laws at the end of the day.
Thanks, Marc-André. I have another question for you. Obviously, in Quebec, we talked about the Quebec Immigrant Investor Program. Are there, and Quebec being a French jurisdiction under civil law, we have a question inquiring about any programs in Ontario without language requirements, and if there's maybe any language requirements in other provinces in Canada.
So that's a very hard question right now. As things stand today, perhaps under certain, obviously under family immigration categories, there's going to be a lot more flexibility under family reunification. But for business immigration purposes, it is currently extremely difficult, if not impossible, generally speaking, to be admitted into one of these business immigration programs, whether federal or provincial, without some basic fluency in French, English, or both. The only exception to that we've seen in the past was the Quebec Immigrant Investor Program, because you're not expected under this program to actually run a business, and therefore language skills are much less relevant in the Canadian context. What the government is primarily interested in getting there is large sums of money. And you don't need to speak any specific language to be able to make that kind of passive investment. But apart from that specific program, which I understand will actually start requiring certain language skills in its next iteration, currently, no, we don't have, to my knowledge, any of these programs with no language requirements.
Thanks, Marc-André. Stephen, we got a question for you that's numerous fold, but I think that we might have time to answer one part of it. There's a law, obviously, with the HKID for certain, people who need to return to Hong Kong for a period of 36 months. Are there any extensions or exceptions due to the current unprecedented circumstances?
All right, well, there's two ways to acquire permanent residency in Hong Kong. The first is if you're a foreign national and you come and you live ordinarily residently here for 7 years, and you're able to convert to permanent residency on the back of that life experience. That can be lost if you have been physically absent from Hong Kong for a period of 36 months or more. In that case, you are downgraded to the right to land, which functionally is the same as permanent residency. It just means that the whole package of rights that go up to and include the right of abode enunciated, having acquired that status via 7 years continuous ordinary residence, is that status is as good as the right of abode that comes with PR in that instance, but you can lose it, and there are implications as a result of losing that. On the other hand, if you have Chinese nationality or a claim to Chinese nationality, that 36-month rule doesn't apply to you, so you're not negatively impacted by the loss. Now, the question is, does the Director of Immigration have any discretion to waive the 3-year requirement as a result of the COVID arrangements now. And the bottom line is no, he doesn't have the power to do that, because that's an instrument of the basic law. And so effectively, there's no way out of losing your right of abroad if you've acquired it via the 7 years continuous ordinary residence pathway.
Thank you very much. Maybe I'll have one last question. We have a question for Raymond. If we have a company that started applying for a green card but is still in prevailing wages status and their H-1B is expiring, it's been 6 years, can they still file for an adjustment for status, stay and work for the company? Can one still travel? Can one file for a green card both via employment and marriage at the same time?
That's a lot of information, and I think to be prudent, I would have to look at the file in order to give a simple answer like that. I mean, but 6 years, I mean, that's a long time. And I think that the law is that if you are legally here and working, you can stay until you get the green card. So with all this marriage, and I don't know who they're marrying to. If they're marrying to a citizen, then it would be a very easy process. So I think I have to take a look at what's going on in order to give an answer like that. Anything that's been there for a long time is needs a little bit better scrutiny.
Of course, of course. I think that this is another question that may be a little personalized as well, but maybe people could reach out to our panelists after the conference. One of the maybe last questions I'll be asking is, I have a situation here from my son who was working in Europe, Finland, in an international company for 3 years. He graduated in CSE and MS machine learning. What is the easiest process and convenient for him if he wants to proceed in Canada? So I think this question is for Marc-André.
Right. So that's to your point, Cindy, that's a fairly personalized question there. It's hard for me to answer without having more information. That being said, that person can reach out to me. And in the meantime, my first instinct would be to look at the express entry platform for skilled workers, which may offer a solution. However, it should also be noted that most successful express entry applicants generally manage to secure a job offer in Canada, or at least have some experience in Canada before applying for permanent residency as skilled workers. So there are different paths to look into. Maybe get a work permit, maybe find a new career opportunity in Canada first, and then apply through express entry. But again, very hard to answer without having more information.
Perfect, thank you. I wanted to just thank all of the panelists. I'm sure I have so many more questions for all of you, but we're already running a little late. So I will, without further ado, welcome my friend, Mr. Jamie Kerr. He is the Vice President of HKCBA in Montreal and the founder and president of Fabco, a Montreal, Asia, China-based custom manufacturer that uses North American standards and processes that are ideally suited for international, Canadian, and US markets. Jamie?
Thank you very much, Cindy. First of all, I'd like to say what a fortunate opportunity for the attendees to have 3 different experts in the room at the same time, with 3 different entry levels to their own countries, being Hong Kong, United States, and Canada. It is really a very unique opportunity. And it was fascinating. The whole conference, listening to it all was very, very interesting. I'd like to thank Marc-André Seguin, first of all, from Canada, Stephen Barnes from Hong Kong by way of Australia, and Raymond Wong for being excellent panelists for us. I'd also like to take this opportunity to say if anybody would like to get a hold of either the HKCBA or HKANY for further information and of all of our upcoming events, you can contact Montreal at hkcba.com or michel.mew at hkany.org. These are also in your comments in the chat section. You'll see the information. There is a couple of upcoming events. There is the Hong Kong Forum on October 21st. There is the Hong Kong cocktail reception for the HKANY. We have the, if you go back one slide, Michelle, to the virtual delegation on October 21st, which is, I attended this last year for the HKCBA, and it's run very well. It's very interesting, a lot of topics, and a lot of insight into the Hong Kong Forum, which happens every year. And also in November, the next slide, Michelle. There we go, the Hong Kong Forum, the 22nd Hong Kong Forum, the second virtual one, I believe, November 30th to December 1st. Again, I would like to thank all of the panelists, and also Donald Moore and Cindy Ho for as colleagues in our Hong Kong, Canada, and America Businessmen's Association. And that's about all. Thank you for joining us.